Welcome to the first section of the NeuroTech course on patents. This first section is what I often call Patents 101. First, a disclaimer. I'm not a patent attorney nor a patent agent. I have been asked to provide this talk because of my professional experiences with teaching and patents in the belief that I will be able to convey information regarding patents in a manner that will relate to your current and future needs. In my professional experience, I have read thousands of patents, been a named inventor on several patents, and have been an occasional expert witness in patent litigation matters. This first segment will cover the basics of patents and intellectual property. For example, what are the types of IP that a person or entity may secure? And how do patents fall within those options? What are the legal standards of patentability? And where does that legal basis come from? What are the patent flavors? And what does that standard patent format look like? There are many other sources of information on this topic in addition to this talk, and we would encourage you to use them to continue to develop your understanding of patents and how they can be impactful to you. As a company evaluates its intellectual worth and credibility, a number of components come to mind. Falling under that umbrella of corporate intellectual capital, this graphic illustrates nicely components that would provide a corporation a competitive advantage and distinguish it amongst others. This includes what is known by the organization and its people in the form of intellectual capital, what is documented in the form of intellectual assets, such as work, instructions, and contracts, and what is often talked about in the form of intellectual property. In this talk, we will present examples of intellectual property that may apply to your organization. IP, or intellectual property, is defined as a product of the mind. That is an idea, invention, artistic expression, etc. Although IP could be in the form of a patent, there are other options as well, including copyrights, trademarks, and trade secrets, all of which we will discuss further in a few minutes. Each form of IP can provide a corporation an advantage in creation of value for that organization and its stakeholders. In some cases, companies may decide not to file patent protection, even though they may have inventive concepts that would warrant the same. These are business decisions that dictate company strategy for IP protection. The four options listed are all legitimate ways of protecting a company's intellectual property. Several factors go into choosing which or a combination of options is used. For example, deciding to keep IP confidential as a trade secret is often chosen by a company for manufacturing processes, particularly for those things that cannot be easily reverse engineered. Patent protection will expire after a period of time, while it is possible to keep trade secrets indefinitely. Filing a patent on a manufacturing process can also provide limited protection because it is difficult to determine if a competitor is actually violating your patent. As an example, Henry Ford revolutionized the manufacturing process and flow of subcomponents when the original Model T Ford was introduced. He had no intention of sharing those novel manufacturing ideas with the rest of the world. He only filed patents on things that could be reversed engineered. Most in the world know the Coke trademark and trade dress, even if they don't speak English. Trade dress IP protection refers to the visual appearance, shape, look, or feel of a product. Sometimes these are covered by design patents, as shown in the Coke bottle figure, which is the original Coke design patent. There are some companies that did not successfully protect their name or image. These include Kleenex and Rollerblade. The general category of their products, tissues and inline skates, are now known by these terms, even though they were originally intended only to be their own product names. When the World Wide Wrestling Federation, WWF, decided it needed to change its identity, they chose the name World Wrestling Federation and applied for a WWF trademark. The World Wildlife Federation sued the Wrestling Federation in the year 2000 for using WWF acronym in the UK, and the Court of Appeals sided with the World Wildlife Federation. Finally, in 2002, the wrestling organization renamed themselves World Wrestling Entertainment with the initials WWE. Also very important to protecting an organization's value are copyrights. While there are many types of copyrights, including literary and artistic work, probably the most familiar are musical copyrights. Following the history of the Beatles' copyrights is an education in how copyrights can be bought and sold while generating vast amounts of value for the owning organization. It may be surprising to you, but the concept of granting and owning patents originated in Article 1, Section 8 of the U.S. Constitution, particularly because owning patents secures an exclusive right to the invention for a fixed amount of time, where the owner has the ability to make, use, and sell its invention or import an embodiment of the invention into the United States. The U.S. Patent and Trademark Office, USPTO, has jurisdiction over the entire patenting process. If you've flown into our nation's capital on a clear day, you may have seen the USPTO on your right-hand side on a descending flight. Many of the patent examiners are located there. Most countries have their own patent offices and processes. Fortunately, one can simultaneously apply for a U.S. patent and many foreign patents through the Patent Cooperation Treaty, or PCT. So why would the U.S. Constitution allow an inventor a monopoly, even for a limited time, for his or her ideas? Is this proper? Why would I say monopoly? Because having a valid patent does exclude anyone else from making, using, or selling an embodiment of what is covered in the patent. The patent owner has exclusive freedom to operate within the boundaries set forth within the patent during the specified period designated by the USPTO. Keep in mind, in exchange for this monopoly, however, the patent must disclose the full invention to the rest of the world. Thus, short-term monopoly, nominally 20 years from the application date, is an exchange for telling everyone in the world about your new concepts, thus giving others a head start to invent the next generation of IP. There are other obligations of the patent owner, including responsibility to protect the usage of the invention, which includes occasional patent maintenance fees, and challenge, perhaps in court, others that you may think might be infringing your patent. What are the criteria for a patent claim to be allowed? There are three. The invention described in the claim or claims must be new, non-obvious, and useful. If the claim concept is found in another patent, in public use more than a year before the patent filing, or in any other publication, then this claim is not described as a new concept. Determination of obviousness is a little bit more complicated. There's a legal notion that there is a so-called person of ordinary skill in the art at the time of the patent application. If such a person would determine that the claimed invention is obvious in view of the prior art, then those claims would not be allowed by the USPTO. As you can imagine, a patent owner and an entity challenging a patent claim or claims might well argue about what such a person might decide about obviousness. Whether a claim is obvious or valid has been the subject of countless court cases. An example of what might not be a useful contribution to society would be to add a non-functional component onto an existing device that does not add any value. Although these three criteria, the invention must be new, non-obvious, and useful, may have a mix of objective and subjective components, they remain the legal bar for patentability. This slide enumerates what is not patentable, including newly discovered laws of nature, formulas, and impossible inventions. I recall several times over the years individuals contacting me saying they had wealthy investors lined up, but only needed an engineer to certify that they had indeed invented a device that would create a new energy source. In each case, these turned out to be a form of a perpetual motion machine that in one way or another had a basic flaw in thinking or violated a basic physics principle. There are three types of US patents. I just mentioned one of those, the design patent, which cannot claim any functional features. Most common is the utility patent, which covers a machine, a process, article of manufacture, or composition of matters. The third type is a plant patent, which describes new varieties of plants, including apples and trees. In 1995, the US Patent Office created a new category of patents, which is called the provisional. I believe this was established, at least in part, to respond to a perceived need where one could lock in an invention priority date, but with a much lower cost hurdle than filing a standard non-provisional patent. At a lower cost, filing a provisional provides 1 year for an inventor, for example, to raise money or to further develop the IP. This application is never examined by anyone at the USPTO, never issued, and expires in 1 year. It does, however, maintain patent rights and a filing date for that year. If a non-provisional is filed within a year, then it can claim the original invention date, but only for the material that is disclosed in the original provisional document. Any new content does not have this privilege. It is useful to understand the sequence of events that lead up to an issued patent as shown here. One can expect that within your organization, there is a standard process for disclosing a potential invention. For new technology deemed worthy, often a provisional patent application is prepared and submitted to the USPTO. Then within a year, a non-provisional patent is submitted. Although it is likely longer than a year before the first response or office action is received from the USPTO, and there may be numerous rounds of rejected claims and counter-arguments by your organization's attorney, a set of issued claims is hopefully eventually allowed, resulting in an issued patent. Let us review the takeaways and teaching points from Section 1, Segment 1 of this presentation. First, generation of new IP can help create economic advantage to a company or an inventor. The U.S. Constitution has created a mechanism by which an inventor can have a limited monopoly and gain income from a new idea, but there is a high bar for patent allowance. Applying for a patent is just one way of securing one's intellectual property and gaining an advantage over one's competition. There are three types of patents: utility, design, and plant. Filing a provisional patent will provide a 1 year cushion for a company to raise money or further refine inventive concepts. Is there a specific format or template for a non-provisional patent application? Indeed, yes. And particularly when you look at the claims where the wording seems unusual. What we might refer to as patent anatomy has a specific order, including a cover page, a specification, which refers to drawings, followed by claims, which describe the invention or inventions. If you were to study patent law, you would learn the specific rules surrounding patent language and other aspects of the application process. Here, we will only cover highlights that would be of importance to a layperson who might wish to file for a patent or understand the basics of patent enactment. Starting with the cover page of the U.S. patent, one can see that there is significant information provided in a standard format. For example, along the top of the page is the primary inventor's name, U.S. patent number, and the issue date for that particular patent. Further critical information is found along the left-hand column, including the patent title, inventor names, and if there is an assignee or patent owner, that named entity. Notice also that the U.S. and international classification numbers, as well as the patent examiner's field of search, are shown in fields 51, 52, and 58. These classifications are useful in searching the patent databases, as will be described later. At the bottom of the cover page is usually one selected drawing from the patent, while the patent abstract, which is a summary of the invention, is found in the right column. Thus, much can be learned from just studying the cover page of the patent. The patent specification not only makes up the majority of the volume of the patent, but also contains significant information in detail about the inventive concepts proposed therein. The figures are referred to, and every important element is signified by a number. By law, the inventors must disclose their concepts in enough depth so that one of ordinary skill in the art can make and use the invention as described. I have witnessed patents being invalidated in court as a competing entity proved that the full invention was not disclosed in the specification or the drawings. The consequence may well be that a multi-million-dollar product is no longer protected by U.S. patents, making a significant financial impact on a particular patent owner. If you own a house, then the boundaries of the property that it sits on is well defined. The town or county that you live in will keep careful records of the boundaries of each plot in its jurisdiction. In the same way, claims for a patent define the scope and boundaries of coverage of the claimed intellectual property. Within those boundaries, the patent owners have garnered a time-limited monopoly and have differentiated from all other patents in prior art. As you may imagine, some claims have more significant scope and coverage than others. Also, there are different types of claims, including independent and dependent claims. As its name suggests, an independent claim stands on its own and is fully complete. A dependent claim refers back to the independent claim and adds on the top of that independent claim. The strategy is to have an independent claim as broad as possible and use the dependent claim to further specify or narrow the description of the invention described in the independent claim. For example, independent claim 1 may include an element that is a tube, where the dependent claim may state the tube of claim 1, wherein the tube is cylindrical and is made of steel. Here, the tube in claim 1 may be of any cross-sectional shape and may be made out of any material, and thus is broader in scope than the dependent claim. Of course, the danger of too broad a claim language is that the patent examiner has an opportunity to look at a much larger volume of prior art when determining whether this particular claim is new, useful, and non-obvious. Thus, crafting claims includes a strategy for trying to be as broad as possible, but at the same time not opening up the patent examiner's search such that the claim will be rejected. Crafting claim language, as the saying goes, is like walking a tightrope. Claims can be further differentiated as method or apparatus claims. As the name suggests, a method claim describes a process or a procedure which is inventive. For example, how a medical device is manufactured, or how a medical device is used when a surgical procedure is performed. The preamble often starts with the phrase, a method of. A transition phrase like comprising then leads to the body of the patent claim, which includes specific components or steps that are anticipated or required in this method claim. An apparatus claim describes the anatomy of an object, system, or machine, including its critical subcomponents. These elements should be connected in some way to each other within the claim language, similar to a knee bone is connected to a thigh bone. The specification can and should help interpret the claim language, hopefully using the same words to describe the same elements. Within a patent claim, one can find functional language, for example, to thereby prevent or control such movement. There may be other clarifying or add-on language, such as shown here. These types of phrases are helpful in defining the invention and help narrow the intended field of use, in part to hopefully narrow the scope of the patent examiner's search of the prior art. As just stated, a typical claim has a preamble followed by a transition phrase, and then the body of the claim, which includes elements of the claim, such as to, as discussed earlier. In order to illustrate the topics of infringement and validity, let's look at an example. Let's say that in the prior art, there is a valid existing patent that includes three elements, A, B, and C. You have filed application 1 that contains elements A, B, and D. The question is, do you infringe the existing patent? In order to infringe, your claim must include each and every element of the existing patent claim. Since element C is missing in application 1, you do not infringe the existing patent. Another company files application 2. Does the claim in this application infringe the existing patent? Indeed, application 2 claim does have each and every element of the existing patent, so there is infringement. Interestingly, however, if element D of application 2 is new, useful, and non-obvious in view of the existing patent, application 2 might receive an allowable claim. However, if the existing patent is valid, then the company submitting application 2 would have to receive a license from the existing patent owner to buy and sell a product under application 2 or be open for a lawsuit. Let's return to your application 1 and dig a little bit deeper. Even though your claim did not contain element C of the existing patent, there is another concern under the doctrine of equivalence statute. If your element D is significantly different than element C, then no problem. But if the existing patent owner successfully argues that D and C are substantially equivalent, as viewed by one of ordinary skill in the art, then application 1 would infringe the existing patent claim. As a summary of section 1, segment 2 of this patent tutorial, what are the takeaways that are important? We notice that patents have similar templates. Although the language and format may be a little strange at first, one can learn to overcome initial reactions and become more comfortable as more experience is gained. It is important to understand the boundaries of the prior art patents and strategically plot out your own. In other words, determine early on what your invention is and what it is not. This understanding should help you, with the assistance of a patent attorney or a patent agent, in developing your own claim set. Study of the prior art will hopefully help you find some white space in the patent landscape. More on this topic in section 2. that will eventually produce allowable claims and basis for defense in court if challenged. Thank you for watching part 1 of the Intellectual Property for NeuroTech course. In part 2, we will continue the discussion on the mechanisms for applying for a patent, how to perform a search to get an understanding of what ideas are already protected, and to identify open areas for you to pursue. We often refer to this as patent landscape analysis. We will conclude with a discussion on some of the business aspects and what you might consider if you are an employee developing new IP. This cartoon illustrates the danger of unintended disclosure of your IP of any type. As a sidebar, I recall attending a medical trade show on behalf of a startup company. As I stood in front of a company's booth, which was active in the clinical area that I was consulting on, a salesperson, evidently talking to an important MD in the field, brought out an advanced prototype of their next generation device. He proceeded to demonstrate the functionality of the device, even though there were many other persons listening besides me. Mind you, I didn't even try to hide my name badge. The private information disclosed told me that the direction of this company in which it was headed was different than we originally thought. This illustrates that everyone in a corporation must understand the importance of secrecy and protection of future IP. In some cases, categories or classes are mature and contain numerous patents. In some cases, it seems as though the patents have been granted with just incremental improvements. Other classes or subclasses are sparser. The population density of a category will indicate the activity level and help dictate the strategy for possible future activity. Notice that the USPTO is a very busy place. For those of you who are part of a large organization, likely the logistics of patent application and its process are mostly taken care of by others. If you do not have this assistance, this slide provides some guidance. There are books and online references that explain the pathway forward for you. An individual can save expenses by creating early drafts of a patent by following guidelines. The inventor knows best the new technology, so there is an efficiency in initiating this documentation. With time and experience, this initial patent writing phase becomes more natural. We would recommend that you consider using a patent attorney as you finalize your draft because they have extensive experience with patent language and will be useful in assuring that the final form of the application is up to the latest legal standards. Although the U.S. has large volumes of patents each year, there are about 153 countries who are part of the World Intellectual Property Organization. Also, China receives the most patent applications. One can file a single PCT application to cover countries, but maintaining filing fees in each country can be expensive. So informed business decisions and trade-offs must be made. Within an organization, the role of the inventor will be spelled out in an individual's employee agreement. Individuals almost always assign rights to any invention over to the employer, making the employer the assignee on the patent. In some cases, there may be some financial compensation for an invention disclosure or a granted patent. At most universities, there can be royalty sharing if indeed there is some income from IP in the future. Determining authorship on patents can be contentious. Human nature can unfortunately lead to disagreements as to who should be listed as inventors. There is pride at stake, and often memories differ about the originations of concepts. Friendships and partnerships have been challenged on this single issue. Authorship is a legal issue and not to be done to please someone or yield to pressure. Only true inventors are to be listed on the patent. If someone's left off or added as an inventor who did not directly contribute to the allowed claims, then a patent can be invalidated in a court of law. I have witnessed several fierce arguments in court on this issue, including referral to old emails and design and manufacturing documents, with the results that the company's patent being disallowed. The best way to avoid this potential devastation of a disallowed patent, especially when the product is already on the market, is to make sure that everyone has the same expectations from day one. All parties should keep detailed notes about the evolution of an idea, preferably in an official design notebook. Also, an organization should have a standard mechanism for dispute resolution. There's great celebration when your patent is allowed. It is quite a milestone, and this does trigger a response to defend this intellectual property if challenged by outside parties. Listed here are other aspects of patent ownership that you should know about. For instance, competitors may choose to challenge the validity of your patent based on their view of what is relevant in the prior art. You must be willing to defend such challenges, which can be very expensive. Even during the patent pending period, you need to be able to demonstrate that you are actively working on the technology and trying to bring it to the marketplace. Other watch-outs are listed here. The process of inventing is not a sprint. It is more akin to a marathon. As a summary for this section, please make sure that you do not put your IP at risk by premature disclosure or improper listing of authorship. Filing internationally is expensive and needs to be a business decision. We recommend using a patent attorney while drafting and filing patents. And finally, patents are often assigned to another party. Now we move on to benefits of analyzing patent landscapes. It's surprising what you can learn by studying the overlapping landscapes of patents and what claims have been allowed. You can discover unmet needs that have already been determined by others. Journal articles and other academic conference publications are another excellent source for understanding past technological solutions to perceived customer needs. Fortunately, there are a number of very helpful patent search websites that assist in finding relevant prior art. While searching, it's helpful to know the classes and subclasses that are most relevant to your technology. Likely, of the 450 classes and numerous subclasses, only a few will be important for your purposes. For example, when searching implantable neurostimulators, you would look at class A61N, which is entitled Electrotherapy, Magnetotherapy, Radiation Therapy, and Ultrasound Therapy. United States Patent and Trademark Office website, USPTO, is an important source for U.S. IP searches at uspto.gov/patents. It has many search features that assist you in finding potential prior art patents and trademarks to benefit your investigation. For trademarks, this site will direct you to the Trademark Electronic Search System, or TESS. On the patent portion of this site, you can perform a basic patent search, along with guidance on what is a patent and the process for filing. Even start the patent filing process online. Within the search functions, there is an option to use full text and image database, or PATFT. The PATFT is a full text database of the USPTO's over 7 million US patents with 3 different search engines: a quick search, an advanced search, and a patent number search. Another reliable source is Google Patents, which indexes north of 87 million patents and pending applications. It includes many search strategies to help you view the landscape from many viewpoints. It also provides search results from all over the world. If you think your invention needs a PCT, this can be a useful starting point. Free Patents Online has search fields similar to the USPTO site and includes other countries as well. You can search published and patent applications, as well as EP, JP, and PCT databases. At this time, German patents are in the beta stage of software development. There are at least 3 reasons for studying the patent landscape: to learn from others, to protect your own intellectual capital, and to avoid infringement of IP owned by individuals or companies. The question asked here, which I witnessed myself, verified that one can learn a lot about corporate strategies from just studying their patent landscape. My wife gains a lot of enjoyment expressing her creativity with her perennial gardens. She has a talent to envision beautiful landscapes to fill empty spaces. While not the same as looking out into a yard and making a spring planting plan, studying the distribution of current patents in a specific field of use helps generate a view of the patent landscape. The trick is to create a way of visually describing this complex geography. One will find, however, that there are boundaries and hopefully white spaces within those boundaries which offer someone freedom to operate. Similar to garden planning, once one knows the lay of the land, one can be creative and generate something of value within otherwise empty spaces. With this perspective, maintenance also becomes simpler over time. Takeaways from this segment include referral to helpful search engines that may assist you in envisioning the current landscape and finding a gap in which you might find freedom to operate. This is not a one-time activity, but necessary to protect your investment and optimize the likelihood of gaining IP protection for your inventive ideas. As you may remember from part 1, it is at this point you should consider the benefit and risks associated with filing a provisional or a non-provisional patent. Continuing, there are firms that one can hire to conduct a freedom to operate analysis that can provide you some confidence in positioning of your IP portfolio. However, there is always a risk even after such a search is commissioned. Let's turn to the business aspects of patents. What do venture capitalists and other investors care about? They care about when they will cash flow on their investment. 2 criteria for making a decision to invest are: 1, who are the people that make up the team? And 2, the strength of the IP portfolio. The value derived will be based on the extent and scope of the claims of the new patent and potentially other IP owned by the same party. One way of viewing that portfolio within the relevant landscape is whether there is a picket fence of other issued or pending IP surrounding the most important inventive ideas. Is the freedom to operate zone small or large? Are there concerning gaps within the fence that a competitor might use to minimize the impact of your IP? Value determination is complex and quite dependent on each specific situation, both on the selling side and the investor viewpoint. The question to be answered is how to create more cash than it costs to create and maintain a patent or trademark. An investor has lots of investment options, so why is your value proposition more attractive? Investor concerns may include, in addition to the patent portfolio, projected revenues and margins, existence of a sales force, supply chain, and built-up demands for products or services that are covered by your IP. Licensing your IP provides a licensee permission to make, use, offer for sale, sell, or import a patented invention. Thus, you gain income and the licensee has a new business. This agreement may be exclusive or have limitations. In-licensing of IP from outside can broaden current patent portfolios and extend your patent protection, resulting in de-risking your business. If done well, new IP partnerships can benefit all parties. There have been cases where in-licensing has resulted in acquisitions and mergers. Licensing out IP should be considered, especially if momentum is stalled for deploying product launches, leaving the IP on the shelf, resulting in accumulating costs associated with protection and maintenance fees. Finding a licensee can address those costs, helping the business financially. Confidential or non-confidential discussions with potential licensees can help determine whether there might be a mutually beneficial license deal. A difficult question you may face is, do you in-license adjacent IP or find a strategic partner to license out your IP to provide income for both parties? My experience is that the longer that this kind of decision is put off, the more likely that the clock will run down and the window of opportunity is gone. This slide lists the questions that you should consider when structuring a deal for out-licensing. What you are after is to determine if there is a fair value proposition for both sides. Once it is determined that there is mutual interest by both parties, then how is a license structured? Details such as upfront payment, royalties, and milestone payments will be customized based on each business situation. Some law firms specialize in acquisitions and licensing and can be helpful. In this section, we will discuss some of the key aspects of licensing IP, either from or to other parties. Each option should be customized for each circumstance to benefit all parties. If you are at a university and have inventive IP, you might consider licensing IP that you have helped create. This happens sometimes when the university decides to abandon any further activity on these concepts. This action does not mean that your invention does not have merit, but only that compared to other options, this case did not rise high enough in a level of importance. If you establish a company of your own to commercialize the patent, it is imperative that you purposely put plans in place to avoid or manage potential conflicts of interest under your university's policies. If that is possible, then this may be an option for you. There are cases where employees invent outside the areas of interest of their company. In this situation, the employee may be able to come up with an agreement with their employer that would allow the employee to pursue ownership of those ideas. Careful negotiation should precede inventive activity and be congruent with the employee's employment contract. There is no guarantee that every company will agree to such an arrangement. This slide provides some insight into what you might do to ensure a successful ongoing partnership with your current employer. Please make sure to review Part 1 if you have not done so. In Part 2 of this talk, we focused on some of the business aspects of patenting, like how do you determine if there's room for new innovation? What is the cost of going it alone versus a patent attorney? What are the options for using a patent or trademark to generate revenue? And what you might consider if you think a patent's priority in your current organization doesn't match what you think is the true potential. New industries have been created in situations where individuals went into new directions with new companies based on IP that did not fit their previous organization. Patenting decisions need to be aligned with an organization's specific and focused business strategy. For the betterment of mankind, somewhat tangential IP may be better nurtured by a different organization than left on a shelf and not applied to real needs. In closing, I'd like to remind you that I am not a patent attorney, and what I've been expressing is based just on my experience. I'm hopeful this is very helpful to you for your journey forward in IP protection of your inventive ideas. Thanks for listening.